started then. This is Carla Reyes, and she is an associate professor down at Southern Methodist University. She's been working on a prototype version of Lexon to rewrite part of the Universal Commercial Code. If did Yeah, I understand the scope of your project there, Carla. Correct me if I'm wrong, because I know I've misphrased it a couple times. But her resume is much longer than I can get into here. She was a Fulbright scholar. She went to Duke University. She sits on multiple advisory boards for legislation around the Universal Commercial Code. So she's definitely one of the foremost experts in this space right now. And I'm really excited to hear more about what she's been doing. I personally haven't been really up to date with any of her research in this area. So I'm personally really excited to kind of get into it and how she's used Lexon and kind of what she's been writing about over the past year or so. So without any further ado, Carla, if you want to get into it, go ahead.
Thanks, Scott, and thanks for inviting me to do this. This is one of my favorite projects to work on at the moment, and so happy to talk about it with anyone who's willing to spend an hour talking about the Uniform Commercial Code. This project really has its genesis in a paper that I wrote in 2017 called Conceptualizing Crypto Law. In it, I argued that smart contracts could be used to implement law and in doing so, bring the law on the books closer to the law in action. So reduce the gap between what is written in statute and what actually happens in the real world. I used in that paper the Article 9 filing system as an example of something that I thought could be improved or implemented via smart contracts. And at the time in 2017, when I posted, look at my paper on Twitter, Professor Matt Bruckner at Howard wrote back and said, it's a cool idea, right? But can you build it though? And at the time I could not, right? So I'm not a programmer. I could not build it on my own. That didn't stop me from replying, sure, I can't wait to work on that project. By the time I didn't know like what that would look like, because I couldn't build it on my own. But around the time I should say that I was first drafting that paper, Henning was also drafting the first white paper about Lexon, and we sort of traded comments on those papers. And now that Lexon is up and running and working programming language, I have in fact been able to build a smart contract based UCC Article 9 filing system. Okay, so for those of you who aren't familiar with either the UCC Article 9 filing system on the one hand or Lexon on the other hand, so I'm not sure who joined us today. I'll definitely in the course of this presentation give a brief introduction to both. So we start with the Article 9 filing system, like what is it and why do we care? So in secured transactions, right? In the lending marketplace, when lenders want to secure the loan, the repayment of the loan by taking a property interest in somebody's collateral, they first have to make that agreement, that property interest enforceable against the debtor via something we call attachment. And then they have to tell the whole world that they did that in order to perfect their security interest. And perfection is what gives a secured lender priority in that collateral. So when the debtor goes bankrupt, the secured creditor can say, I'm first in line in reclaiming the value of that collateral to pay down the debt that I was owed. And so perfection is quite important. And although there are a variety of ways perhaps to perfect in collateral, depending on what the kind of collateral is, the most common way to perfect security interest by far is by filing what is known as a financing statement in the Article 9 filing system. And it is that financing statement that I seek to automate. I want to both, I have attempted to both, create a smart contract-based version of the financing statement, but also automate a variety of rules that sort of surround the financing statement and the filing system to make it work the way that it's supposed to. So you say, wait, it doesn't work the way it's supposed to? You just made it sound really important. Yeah, I know. But it doesn't work the way that it's supposed to. So the filing system is supposed to give creditors, other creditors notice, right? So if I'm secured party one, I file my financing statement to tell everyone that I have, that I may have, frankly, that's about all you can know, but that I may have taken a security interest in this type of collateral. And that if you, the second potential secured party, are thinking about lending to the same debtor and taking the same type of collateral, assets as collateral, you should do additional due diligence. That's what the financing statement is supposed to tell you. So it's supposed to put the world on notice. It's supposed to serve a notice function. Unfortunately, it does not often provide actual notice. So the information that you get when you search your secured party number two and you think, okay, I'm going to protect myself, make sure the debtor is telling me the truth about their outstanding obligations and the assets that they've pledged to those obligations, I'm going to go search the filing system. You do that. You search the filing system and you don't find anything. The truth of the matter is you can't actually rely fully on the fact that you didn't find anything as evidence that there's nothing to find, right? There are a variety of reasons why the system fails, and essentially then the system fails in general to provide future secured parties with actual notice of existing or pre-existing liens. So in other words, the system does not function the way that it is intended. And so the UCC also contains a variety of rules designed to mitigate the risk of loss attendant when the filing system does not work as intended. And those rules, I spend a good chunk of each semester with my students discussing. What happens when the filing office indexes the financing statement wrong, and because of the indexing error, you can't find the statement? What happens when it's because the secured party put in the debtor's name incorrectly? What happens when the name was put in correctly, but it was a trade name and not the actual corporate name, right? What is the actual corporate name? All of these rules are quite detailed and quite many. There's a variety of them that take quite a lot of time to teach in the class, and continue to provide sort of, or present traps, I think, for the unwary in the commercial filing system. Indeed, the filing system is so complicated that there's a case in like nearly every secured transactions textbook that's supposed to be like a warning sign for students, like don't underestimate the importance of the filing system, where essentially two really well-meaning lawyers did their best to understand the filing system but didn't. And as a result of a very simple error, they cost their client essentially $1.5 million, or billion dollars, I should say, right? So really important, really complicated, and the complications can lead to huge financial losses. So when it comes to these shortcomings of the filing system, at the root of it, the problem is that it's difficult for all the parties in the secure transactions marketplace to be sure that they are looking at the same record of evolving facts at any given point in time about secure transactions that exist, about security interests and their status and perfection. So, and that problem, since that's the core of it, if you think of it as at a functional level, that is why I have argued since 2017 that I think blockchain technology and smart contracts is provides an opportunity to improve the system, because that is what blockchain technology does really well. Blockchain technology enables parties that don't necessarily know each other to reach an agreement about the existence and evolution of shared facts between them. And that is what the secure transactions filing system cannot seem to achieve, no matter what it does. So why don't we use the technology designed to do that to fix the filing system? And so that was the proposal, and that Professor Bruckner challenged me to just go build then. And so when I finally was able to use Lexon, or try to use Lexon to build it on my own, I would say in the interim, before Lexon was functioning, I actually asked computer science students to try and help me build it, and that was difficult because I couldn't quite translate what I needed from a legal perspective to what they wanted to build in Solidity. It was just, there's a translation piece that didn't quite ever work out. And so I was really excited when I could sit down with the white paper and eventually the books, and we can't see that because of my background, but eventually the books, and try and program it myself in Lexon. When I did so, I had a couple of goals in mind for the prototype, if you want to call it that, or for what I think I'm referring to as the Lex UCC financing statement. Namely, I wanted to do more than create just a digital version of the UCC1 form. The UCC1 form is what we call the financing statement, because there's a specific form outlined in the UCC that if you use it, you get safe harbor, because and it's accepted, you get a type of safe harbor for including all the requisite information, right? So I wanted to do more than just provide a digital version of the UCC1 form, because that already exists. There are a variety of states that already accept electronic filing, so like that's not new. What I really want to do is automate as many of the existing Article 9 rules related to those UCC financing statements as possible. And wherever possible, to also show that whatever I created could be implemented now under existing law. So making sure that it was compatible with existing law was particular importance in terms of goals of building the prototype. I also, wherever possible, wanted to demonstrate the possibility for building new innovations, ways to improve upon the system that don't require changes to the law, but nevertheless represent things that filing offices and parties don't do right now, largely because the technology that they use right now doesn't enable it, right? But if done well, if I could get just these two things, right? If I could automate rules in a way that's compatible with existing law, and if I could show just a few innovations using the technology in the system, then achieving those two things alone, my hypothesis was and is that I would be able to cause sort of ripple effects throughout the Article 9 filing system that would ultimately lead to simplification of the law in practice. Like basically, if states would adopt this system, I think I can stop teaching those rules for like a month in my class, and we can focus in more depth on the other things that we sort of survey. And that's the basic idea. Okay, so what does it like? Why is it what is it a big deal that I could use Lexon now instead of asking computer science students to build it for me in Solidity directly? Well, Lexon is a new type of programming language that reads like English, and so you don't really have to have any programming training to understand it, right? So like I said, I'm not a programmer. I have zero programming training. You can build it to run, it can compile to Solidity, to Sophia, and it can also be run as a JavaScript program on non-blockchain servers, right? It can be run offline. You can, of course, if you build it to compile to Solidity or Sophia, you can run it as a smart contract on a blockchain. But for me, the key piece is, so although Lexon is built to be readable, right? The emphasis is on readability. I've also found that I could actually try and just write it too, right? And the books, which I love and I recommend if you want to learn more about Lexon, say that enabling someone like me to write it wasn't necessarily an original goal of building Lexon. And yet when I built the project or tried to build it for the first time, like what I did was, at the time the books didn't exist, but I sat down with the white paper and read it. And then I sat down with a Word document and tried to type out the code that I thought would work, right? And I didn't get it quite right. And I had to go to Henning and say, okay, this is what I came up with, like, what am I doing wrong? And it's been a sort of iterative process to eventually get to a place where I use the Lexon Bible with the explanations of the words that Lexon recognizes to build a version that does compile to Solidity in the Lexon editor app, in the Lexon editor. I think, I don't know if that's what I'm supposed to call it, but the thing on the Lexon website where you can go and build your programs and see it compile to Solidity. The thing about Lexon is that it is sort of a 6th generation programming language in that, right? It's in plain English. It was built primarily with smart contracts in mind, right? To enable smart contracts that folks want to use as legally enforceable contracts to be read by lawyers natively and judges natively to sort of avoid the battle of the experts, right? But the reality is that it can be used for a variety of other purposes as well, including, in my case, implementing law. And you say, you just built a form. Yeah, I built a form, but I also automated legal requirements around that form. And so it is, the prototype is implementing law. So here's the UCC1 financing statement that I've been talking about. This is what we use now. Yes, it is in fact a PDF. It's a PDF form. And depending on what state you are in, you may print this PDF out and fill it out and submit it in person, like turn it in. You might fill it out, save it, attach it to an email and submit it. You might similarly fill it out, save it, and upload it to an electronic filing system, right? And some states do have like a digital version where you're literally filling in fields in a user interface, right? You're not filling out the form. So there are a variety of ways states implement this. And usually, I would say even the states with the sort of most advanced option to fill in a interactive user interface, the fields of the form, it's optional. So you could still always print out the PDF and like walk it in, maybe not in COVID land, right? But because of shutdowns, but the variety of implementations are often optional. The point is, though, you have to have certain information when you file. So you have to say, if you're the filer, you include your filing information. The filer may or may not be the secured party. It might be the attorney of the secured party, for example. It might be in-house counsel. You have to include the debtor's name, whether the debtor is an individual or an organization, their address, the secured party's name, an address, and then a description of the collateral. These are the key pieces of the form. There are also almost identical forms with just slight variations for things called continuation statements and termination statements, which we'll talk about a little bit later, assuming I get that far. But basically, like, this is the thrust of the thing that I wanted to turn into a smart contract based system. So the first thing to automate, I would say, is basic requirements in the UCC relating to the filing office, things that participants in the secured transactions marketplace often take for granted. So like the fact that each UCC financing statement gets a file number assigned to it when it is filed. The filing office is the place where you file it. The filing office is also the place that, or the entity that assigns the filing number. And so because those are provisions in the UCC, those are requirements, right? And so for any state that has adopted the uniform version of the UCC, which is most states until some recent amendments related to digital assets specifically, these would be requirements, right? So the system that I build needs to assign file numbers. It needs to have the filing system assign the file numbers, or the filing office assign the filing numbers. And the filing office needs to be the place that the state has designated to be the filing office. Normally that's the Secretary of State's office, although it doesn't have to be. It can be a private entity if they want it, for example. But most states have assigned it the Secretary of State as their filing office. Okay, so the point here is even the very basic sort of backdrop, the architectural backdrop of just how the filing system works needed to be considered when we automate the system. And so the Lexon version starts with these basics, including definitions. So I don't know, again, I'm not sure who's with us today. So if I'm going over Lexon stuff, that's basic, sorry. But just in case, you ignore this title UCC fine, right? That's just the title of the document that I wrote on, right? But this piece that starts Lex UCC financing statement, that's the start of the code. And then the definitions here is sort of doing a bunch of this setup stuff that I've talked about. So saying what the file number is, namely that it's a hash of the data that you're submitting as the financing statement. Saying that a filer is a person and you're required to give their name and their phone number and their email. So in other words, setting up a template to be filled out just like the actual financing statement, only it would be digital. So you have to imagine that the thing that represented here in Lexon is the back end of the system, and there'd be a user interface sitting on top of it where people go to the website and they see fillable fields just like they would now, right? If in a state that enables fillable field filing, direct electronic filings. And so they go in and they fill in the required information for the filer and for the debtor and for the secured party. The filing office, of course, would be the Secretary of State's office, but it would need to be represented in the Lexon, the Lex UCC financing statement system as a key address, a public-private key address pair, right? So that it would be able to sign things like the file number, like the, as you'll see, continuation statement notification, etc. There would be a field for collateral. You would still be able to use UCC categories of collateral. So it would be data that you would input. You could, however, if you wanted, and we'll get to this, but this would be sort of an innovation. You could identify specific pieces of collateral using a hash, for example, a hash of a serial number of equipment you could use. But typically, I would say commercial practice is to use UCC category of collateral in the collateral description, and this financing statement system would not obviate that, right? I don't want to touch that at all. I want to enable folks to continue doing what they normally do, while at the same time enabling new commercial practices if people wanted to use them, right? Which is this idea of identifying collateral by a hash of their serial number, for example. And there are a few other definitions here that I don't want to get into just yet, but just the point of this slide is the program starts with definitions, a lot the same way that a contract for lawyers may start or sometimes end, right? Sometimes we bury the definition section at the end, but the same way that a contract, regular legally enforceable contract would have definitions, that's how the Lexon program starts. And for my purposes, the key definitions here are both ones that enable the infrastructure that we don't often think about for the filing system, but also the definitions that literally would build the fillable fields for the financing statement. So again, as we go through, just imagine that or remember that the Lexon code is building a template that would be sort of used over and over and over, and that the actual filer wouldn't ever see. Like the filer is not going to go read this text. The filer would go to the user interface and enter stuff the way they normally would. But on the back end, the Secretary of State's office would have adopted this. And the reason for keeping it in English, you're like, well, if that's true, why does it have to be in English? Well, so the Secretary of State knows that it's fulfilling its own legal obligations, right? Because there are obligations of the filing office included in the UCC, and there are repercussions for the parties, not often for the filing office, but there are repercussions for the parties if they don't fulfill those obligations. So in order to assure that they need to know what the code says, and having it in English enables them to know that. this is the actual text of the UCC with regard to the term financing statement, continuation statement, and termination statement. So it's just worth noting that in UCC speak, the financing statement is actually the whole file of documents relating to the initial financing statement. So the first time you file a UCC-1 form, that's the initial financing statement. And then they only last for 5 years. They're only good for 5 years, and then they lapse. And so you would file a continuation statement to continue it for another 5 years. And there's a window that you're required, in which you're required to file a continuation statement, namely 6 months before the lapse date. But when you file the continuation statement, now together, the initial statement and the continuation statement together is the financing statement, right? It's the whole file of things. So the financing statement means the record or records composed of an initial financing statement and any filed record relating to that statement later. Again, the continuation statement is the thing that enables you to continue for another 5 years. Secured loans aren't often repaid in just 5 years, right? So being able to continue your financing statement is important in order to maintain your perfection and your place in line in case your debtor gets into financial trouble. And then if in fact your debtor pays off the outstanding obligation, you would file a term, you could, you don't necessarily do, but you could file a termination statement to indicate the extinguishment of your security interest in that collateral. Now, there's a variety of reasons why you might not do that. Like maybe it's a revolving loan, and so paying off the balance just means like maybe in a week there's another extension of credit that is attached to the same collateral, right? So there's any number of reasons why you might not file a termination statement, but if you did, what it does is terminate, as the name implies, the original initial financing statement and anything else that's been made part of the financing statement, so that it's no longer effective. The reason to point this out is because this all has to be automated in the Lex UCC financing statement, right? And it is. And so we include definitions for each of these, including the financing statement, the initial statement, and to represent the idea that there could be amendments, including assignments or other things in the middle. We have this concept of a list of amendments. And the reason for including a list of amendments is to emphasize that you could use the file number to like literally pull all the records from the system related to the initial financing statement, right? Which is one of the requirements of the filing office. So again, it's all about ensuring that the filing office can continue to meet its obligations under the UCC, and it's in English so that they know that they can. And there is definition of default here, and I'm not gonna, so just note that it's there, and we'll pick it up in a minute when we talk about the clause related to defaults, because that's part of like one of the innovations that I wanted to demonstrate in the system. But again, this is offering to you the text of the UCC that represents some of the filing office's obligations in relation to operating the filing system. But it's worth noting that to the extent that the filing office causes any errors in its performance of these obligations, that often the risk of loss associated with those errors are borne by the parties in the system, either the secured party one or any subsequent secured parties. And so part of what's happening in automating these things and ensuring that it's very difficult for the filing office to make errors, right, is mitigating the risk of loss posed by errors to secured parties in the system. And one of the innovations is also to help protect the debtors. But again, we'll get there. But for any UCC folks on the joining us today. I just want to point out, I have thought about benefiting the debtors as much as benefiting the secured parties. One of the goals of the system is not to benefit one more than the other. It's supposed to be relatively balanced, and so I have thought about balancing it out. But this in particular, automating the filing office obligations, it does have the effect of mitigating risks that would otherwise be borne by the secured parties. So we have the definitions in the Lexon program first, and then come the recitals. And the recitals are, again, designed to sort of set up the architecture that we take for granted in the system. So, for example, the filer is the one that sets the debtor, the secured party, the collateral, and to the extent any is included, the digital asset collateral. And again, that's one of the innovations that I would just want to illustrate could happen, not that it has to happen. But the point here is this piece sets up the fact that it's the filer who will take those actions and not the filing office, not the debtor, for example. Although frankly, the system will have no particular way of knowing if it's a debtor or secured party who is being the filer, right? And that's true under the existing system too. But the idea here is to set up the architecture as we know it, just in code. If the filer is filing an amendment, including a continuation statement or a termination statement, they also have to set the amended filing number, namely include the file number from the initial financing statement as the filing number. And if it is, then the list of amendments will capture that record in relation to the original one when someone goes to call on the entire file, the entire financing statement file. In creating these recitals, I'm actually automating UCC sections 9, 519A, and limiting risk associated with the 9.517, which is what assigns the risk of loss in the event of an error. Another provision that we seek to automate in the prototype is 9.515, and this goes to this idea that financing statements are good for only 5 years, and that at the end of the 5 years, the statement will lapse unless you file the continuation statement within the 6-month window just prior to the lapse date. If you don't file a continuation statement at lapse, the security interest that was perfected by the financing statement becomes unperfected unless you've perfected it by some other method, for example, via possession, right? But generally speaking, it's treated as though it's unperfected. This piece, sort of remembering to file continuation statements on time within that 6-month window, and understanding eventually sort of the recurring cycle of 6-month windows and lapse dates can be quite complicated, and is often a source of attorney error or filer error, and sometimes a problem with regard to malpractice claims. And so it's a real, like, if we could clean that up, that would actually benefit the system quite a bit. And so the goal of the program is to indeed automate that, this time using clauses, right? So if you imagine the Lexon program, it has the header, it's the Lex UCC financing statement, then it has the definitions, then the recitals, and now the clauses, right? So a lot like a contract that a lawyer would write in regular English, non-Lexon English, right? So each clause starts clause with the name of the clause, so that so it can be recognized as such. But here we have the clauses that automate the lapse date, meaning 5 years from the date that the initial financing statement was filed, or 5 years after the continuation statement was filed, whichever one is later in time. It automates calculation of the continuation window, and says essentially that you are allowed, if you are the secured party or the filer, to certify that you're filing a continuation statement only during that 6-month window, which are the rules. So essentially just automating 9/5/15. This is one area where there's a potential opportunity for innovation, namely, it's an opportunity for the filing office to generate new fees, which is always something the filing office is interested in. It's also an opportunity to offer sort of an external reminder, or a reminder from an external source, sort of a fail-safe for folks who are in charge of remembering to file continuation statements. So namely, you could use the sort of an escrow capability of smart contracts to pay in a reminder fee if you're the secured party. If you're a secured party and you want to be reminded, you pay in a reminder fee into escrow, and the filing office can choose, if it wants to send a notification to the secured party that, hey, your continuation window has begun and you need to file a continuation statement if you intend to within the next 6 months. If it sends the notification, then it could pay the reminder fee out to the filing office. So again, use the escrow functionality of smart contracts to generate fees. And if the filing office chooses not to send a continuation statement, either because they just decided they didn't want to do that, or because there was some error and they just didn't in this particular case, then the reminder fee would just stay there until lapse in clearing, at which point the reminder fee would be returned to the secured party. So the secured party isn't out anything if they don't get the benefit of the reminder, and the filing office only earns it if in fact they send a reminder. The prototype also tries to automate 9/5/22. Namely, the filing office is required to retain the financing statement, so the whole file related to an initial financing statement for 1 year after the lapse date, so you can't clear out the system until then. But the filing system is intended to be a self-clearing system, and so after 1 year, it's supposed to clear the records out. It doesn't always, though, and so sometimes the search will hit on old stuff, and it's hard to tell what's old, etc., for the searcher. So if we could automate the clearing of the records, that's another opportunity to reduce ambiguity and improve the way the system works as compared to the way that it was intended to work. The clause designed to do that is to note that a secured party can always terminate the financing statement when it wants to. And if it does, a year after either the termination statement or the lapse date, then the filing office automatically clears out the records. So we automate 9/5/22 to improve clarity and certainty in the system. This is another area of potential innovation, and there are actually 3 more or so that I won't talk about today, but that will be in the sort of longer paper on this topic that will be out soon. But one possibility is, right, so there's a lot of, and again, I don't know who's joined me today, but there's a lot of discussion right now among both state legislatures and international bodies related to harmonization of private law, commercial private law, to think about how to treat digital assets under commercial law principles, particularly with regard to secured transactions. And there's a lot of ongoing discussion there. Some states have taken it into their own hands and gone ahead and changed some of the rules such that their UCC are not uniform. And some of those changes are quite helpful. The problem is because it's not uniform, it only applies to the extent that that state law applies to the transaction, right? And given the nature of digital assets and they move around and it's not clear where necessarily they're located, where the debtor is located, then it's not clear that that's 1, 2, maybe 3 states at this point that their law applies. In that case, the existing law would apply, and it's although I won't say it's confusing, it's relatively clear. There's a lot of discussion out there that says the treatment of digital assets under Article 9 is not clear. I don't think that's true. I think there's a general consensus that they're general intangibles. The problem is the treatment of general intangibles isn't very helpful to assets that are intended to be highly negotiable, right? So take free rules and don't apply in the same way that they do to money, right? There's no super negotiability. And so it interferes with downstream transfers of the asset. So in any event, this has nothing to do with any of that, is what I'm trying to say. But it does address it demonstrates one potential solution, and I don't even know that it's the best solution, but it is quite elegant in terms of like, how do you take control of, assuming eventually one of the solutions to the general intangible downstream take free things is to think about control the same way we think about deposit accounts and control for perfection rather than filing. There are, however, practical concerns around that maybe for the industry. And one way to solve that within the filing system itself might be to go ahead and pay digital asset collateral into escrow in the financing statement itself, such that the escrow in the financing statement is a method of perfection. And again, this innovation would require more of a change in existing law than the general goals for this project would prefer. But the idea is simply to demonstrate that there is innovation potential here. Essentially, if the secured party were to certify that a default had occurred, the filing office could release the digital asset collateral to the secured party. And if the secured party were to terminate the financing statement related to the digital asset collateral, then it would return to the debtor to whom it belongs. But again, this is a potential innovation, just sort of a, I am a law professor, sort of a theoretical demonstration of the capability, but would require, unlike the rest of what we've discussed so far, would require change to existing law. So what have I learned from my work with Lexon? Namely, it is possible to do what I theorized in the 2017 paper to build what I called crypto legal structures, basically to implement law through smart contracts. In fact, it's possible for lawyers to do it using Lexon, because I can write English, I can write Lexon. I did learn, however, that writing in Lexon, writing code in Lexon required a bit of a change in the mental model. I didn't want to write the clauses the way they needed to be written initially in Lexon. I just had to think a little bit differently about the syntax, and that was fine. It just took like I said, a bit of a mental model shift. But in addition, it's not just the syntax, it's thinking about including the automation of the architecture, right? The initial setting up. So what definitions must be included, what goes in the recitals, that piece required just simply recognizing like the unspoken pieces of the system that I don't think about regularly, right? That I don't actually engage very often. Sort of the hidden pieces that we've just been accustomed to existing, but don't really think about how they operate in the law. But over time, through the iterations, adjusting my approach in this way actually increased the usefulness of the draft rather than reduced its usefulness. Like, it didn't make it less readable by any stretch of the imagination. It helped in its readability. And ultimately, like I said at the outset, this has been, still is among my absolute favorite projects to have worked on in the last couple of years. And I'm really looking forward to trying my hand at another draft in Lexon.